Okay, good morning. Yes, I haven't gotten this thing done. It's finished, so now I'm going to email it to the court. It's not to be emailed, it's supposed to be uploaded to their database, but I haven't been able to do that yet. I'm hoping that that situation is going to be resolved by the end of today, but I don't know. So, just to be on the safe side, I'm going to email it to them, which I'm not supposed to because I'm a lawyer. But then they're going to say, "Oh, you missed a deadline, so you can't file your appeal." So I'm going to email it, and then I'm going to try to resolve the issues with the upload. And I just sent it out also to all of the big shots in England, namely James Cleverly, Suella Braverman, Victoria Prentice, Michael Tomlinson, all those people. So I'm going to do this, and then I'm going to email this, and then I'll check out what's happening with Harry and Meghan. Okay, so I just did my Harry and Meghan video, and I thought I would come back. I'm obsessed with my appeal. I actually love the process of writing. I was surprised. I was surprised. I mean, here's the thing. It's very difficult, and I've come to realize that, look, I don't want to do this for a living. You know what I mean? It's not just a question of loving to write, because I really enjoyed doing this appeal, even though it's really, really difficult. It's a lot of stress, but you have to also, there are other things that come with practicing law that I'm not suited for it at all. But so I really enjoyed writing the motion, and I wanted to read you a part of it. And because one of the things the judge, she denied my motions for my injunctions, and I think that she erred. I think it was an error on the part of the district court to deny my motions. And one of the things she said was that I waited too long to file my motion. She basically said that in New York, I have to file my motion within 2 months, and I filed in 3 months. And so for that reason, I'm cut off. Nothing the court can do for me. This is, her idea of justice. And for me, this is just not justice. And it, et cetera, et cetera, et cetera. So I wanted to share what I wrote with you. Don't laugh. It's not funny. Okay. So I said, the district court furthermore penalized the undersigned for not running into court like a chicken without a head, seeking a speedy TRO. A TRO is a temporary restraining order, like everyone else would probably have done in this situation, and for waiting 3 months before moving for injunctive relief. But this was error on the part of the court below. The undersigned was not trying to be Speedy Gonzales, because that would have been the wrong strategy in this case. The undersigned thought a better strategy was to move more dilatorily for these drastic remedies against these particular defendants. The government of England and the British monarchy are not just anybody after all. One does not move speedily in putting an unprecedented injunction on the British Crown estate. This is very serious business. It is right up there with arresting a former US president. But it is part of the duty of the lawyer to assess every situation in a case and use the right strategies to adequately represent her clients with vigor. Sometimes adequate representation means thinking out of the box and doing things counterintuitively. A good lawyer needs to know when to think outside the box. A good lawyer needs to know when to color outside the lines. A good lawyer cannot be so predictable as to do things the same way that everybody else does, or take a cookie cutter approach to lawyering. To fully and adequately represent her clients, a good lawyer needs to be original sometimes. What was the right move? Speedy TRO or a motion for a preliminary injunction? Which way should I do it? The late, great Frank Sinatra's voice came to me from the grave and said, "And now the end is here. And so I face that final curtain. My friend, I'll make it clear. I'll state my case, of which I'm certain. I've lived a life that's full. I traveled each and every highway. And more, much more, I did it my way." I should have said here, the undersigned, but instead I said I. And it's too late, I've already sent it to them. So I said, "I made the decision to move for a preliminary injunction. It is drastic to move for such daring injunctions against powerful defendants like these, and give the powerful defendants notice that you are doing it. It is counterintuitive to have waited and then to have moved slowly and openly and notoriously by giving them notice rather than pouncing like a leopard, which, to be perfectly honest, might have been my preferred way. But these injunctions requested by the undersigned required that the undersigned exercised restraint, and the undersigned should be commended for her restraint and not criticized that she did not move fast enough. The timing of the requests were part of the studied strategic advocacy that the undersigned deemed necessary against much more powerful and clever defendants who could easily undercut judicial authority and evade the judgment she gets at the end as if it is tissue paper at the bottom of their shoe without more backing from the court. These injunctions are critical, and they are cerebral plays that the undersigned has deemed to be outcome determinative. I don't know why there isn't a dash there, because there was one when I did it, right? In her case. Admittedly, this is not a move for the faint of heart. It was not a move for the uncreative and the predictable. It was not a move to be done speedily like the headless Mrs. Gonzales. The undersigned specifically needed to keep her head on her shoulders in such a drastic situation. Whereas another attorney in the same situation might have moved with breakneck speed with a TRO to get these injunctions, the undersigned instead chose to move more slowly like an elephant. Sometimes this is what vigor looks like.